IVM.
I want to thank Intel for supporting our show. Do you remember last year when we spoke about how the Intel vPro platform is built for business? Well, I'm glad to say we've kicked it up a notch. That's right, Intel is back with a new and improved version of the platform. The new Intel vPro platform lets you do more of what you want and less of what you don't. So it's better for you and for your IT teams, who really are the backbone of keeping your work-from-home experience easy and enjoyable. I can safely say that the new vPro platform gives you more enterprise efficiency with less constraints. Visit intel.in/morewithvpro, that's VPRO, to discover how you can get more done with less waiting. If you're listening on the IVM Podcast Android app, click the link that's visible to you now.
Welcome to All Things Policy, a daily podcast by the Takshashila Institution. We are a bunch of policy nerds based in Bengaluru, and we like bringing fresh perspectives to Indian affairs and Indian perspectives to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hello and welcome to All Things Policy. My name is Rohan, and we're here with a very special guest, Supreme Court advocate and advisor to the Esya Centre, Gopal Jain. I'm also here with my friend and colleague, Prateek Waghre, and we have a very special episode coming up discussing Section 69A of the IT Act. Regular listeners of tech episodes on All Things Policy know that we talk a lot about tech on this show, especially around content moderation, around just speech, hate speech, so misinformation, information disorder, Prateek, and so on. So I think we will put some context here because there's going to be a fair bit of legal speaking here. Because, we have Gopal with us. So, Gopal, could you please go ahead and tell us a little bit about the IT Act and where it comes from, the origins of it?
Look, the IT Act, when it was formulated, dates back to the year 2000, when the world was vastly different. And therefore, the provisions which were set within the framework of the Act were very contextual for that particular period of time. And now we've seen a complete change, both in terms of technology and in terms of India moving towards digitization and a digital economy. So Section 69A at that time was a power which was given for blocking of public access for any information using a computer resource. Now, while the objective is very clear that it gives you some form of access or directions for blocking access, but the question is, how was it really used in practice over a particular period of time? Was it in line with what it was supposed to be, or were there cases where there was, unchecked discretion which was used? And that has to be seen through the lens of hindsight as things go. And this provision really came by way of that amendment to the Act in the year 2000. And as we debate a modern Indian society, which is sort of the new age India, we've got to see whether all these things have served their purpose, not served their purpose. And a lot of it is based on what I call ground realities.
What sticks out to me when you talk about Section 69A specifically, it's that it's outdated in the sense that it's too broad a mandate, personally speaking, although I'm not the expert on this. But it seems like too broad a mandate when you talk about just computer resources. And also it's developed in a time where the internet doesn't exist as it currently exists today. So do you think, Gopal, that this mandate's too broad? How do you think this should be changed? How do you think this should be looked at?
The way it is cast, it's very wide, really, in terms of computer resources. Today, we are in an internet regime, right? And when you look at the internet regime, it should come with its own protocols. And that's where I think there's a need for change. There's a need for rethink. There's a need for changing the entire act in line with the ecosystem, or what I call a digital economy. And that's what I think we should discuss, debate, and strategize. What would be the right framework for an internet economy?
Okay, you've written this excellent op-ed for Financial Times, if I'm not wrong. And in the op-ed, you talk about Section 69A needs to be seen in context and perspective of transformative potential that India holds to become a truly digital economy, right? And you say that this IT Act, the Section 69A specifically, can be a major hurdle. And because especially because it's used in a non-transparent manner and is used extensively. So give us some examples of how it's being used in a non-transparent manner and recent use cases of the 69A.
Yes, I think transparency like sunlight is the best disinfectant. And if you look at all enactments, including the right to information, what people want to really know is why decisions are made, why certain actions are taken. So it should be out there in the whole public domain, particularly given the fact that India is a very fast growing digital economy. We have over 500 million connected internet users, and therefore the internet offers to them not just access to information, but really gives opportunities for India and Indians for economic, cultural, and social empowerment. So they really want to know what's happening. And when you have decisions which are taken, blocking certain apps, decisions which are made, people want to know the reasons. So I always say there's sometimes a tiff between power and popularity. What is necessarily popular must be supported. But power doesn't look at popularity. Power just looks at the source of the act in which it is based. And depending on circumstances, it is exercised. But there must be, according to me, defined triggers for it, informed decision-making, and very clear, cogent reasons which are put in the public domain. So people would have a sense of why a certain action has been taken, particularly because these are extreme actions that we are looking at.
All right. So in the op-ed, you gave a couple of great examples when you talk about how the act has been used to, let's say, block environmental activism websites. You talk about Fridays for Future, Let India Breathe, There Is No Earth Week. Also, you talk about some websites of the UN organizations, health group, health forums, feminist groups. So, two questions there. Firstly, is there a kind of a pattern that you've seen why these particular websites are being blocked? And secondly, is there a process that is followed every time a website has to be blocked? Is there a certain set of actions that need to happen so that we find out that these have been blocked? Or do you just randomly stumble into blocked websites and then you say that, well, this has happened?
Well, I think in the examples that I gave and the ones that you mentioned, there seems to be a clear pattern. And I think it really boils down to using the word from the world of food, palatable and unpalatable. So nobody wants to hear unpalatable things. Nobody wants to see unpalatable things. And if you have a power, you say, well, why not? Let's give it a shot. Let's exercise it because it immediately achieves that particular purpose. So there seems to be some kind of a thread or a pattern which I see. Second, and most importantly, that even the Supreme Court has said that all actions have to be based on proportionality. So there has to be a graded response. If I go late to school, I shouldn't be rusticated from school. So in the same manner, whenever we look at a ban, a block, or a prohibition, it's always a measure of last resort. Every other means must be first exhausted before one takes that extreme action. So, for example, in many jurisdictions, they may make a distinction between content which is manifestly unlawful and therefore give an opportunity for those platforms, say 24 hours, 36 hours, or 48 hours, that you please take down such content. If it is less severe, you get a little more time. So the idea is give an opportunity, consider what the specific case is which should be, and then have a graded response pattern which is informed, discloses reason, and follows a fair process. And this takes me to a very pet theme of mine, which is what I call due process. So the Indian constitution makers were very prescient. They provided for what I call the due process of law. And Article 21, which is the article of right to life, one of the most important articles in the constitution, also said due process of law, which is a kind of a constitutional safeguard. So this is where I believe that the rule of law recognizes that the process which is followed while making any decision must follow due process, must have a transparent procedure, and above all, decisions which are taken must be fair and proportional to meet the exigencies of a particular situation.
And if I can just add, right, so there was this, earlier in the year, there was this paper that the folks at CIS had done, where, and it was more from the technical perspective. They were analyzing how different ISPs block websites in India. But there was one interesting data point there where they looked at the source of these blocked URL, right? And they basically split that into government orders, court orders, and user reports. Now, let me go in reverse order, right? So for the purpose of that report, I think user reports, they got about 60 odd URLs, close to about 9,300 URLs through court orders. And government orders, they were only able to identify 890 URLs, which are all, which are either publicly reported or leaked, right? But the point remains that because of the confidentiality clause, it isn't possible. You don't really know which URLs are blocked by the government, which URLs aren't, right? Even in the case that we were talking about, the Fridays for Future, Let India Breathe, etc. It took a lot of reporting and a lot of digging around and investigative work to determine the cause of the rules and the cause under which these URLs were blocked, right? And if I remember, Internet Freedom Foundation was doing a bit of advocacy there as well, right? So I think this goes back to the point earlier, right, about transparency of these of these rules.
Yes. So I think, as you rightly said, it's all about going to the root. What is the root cause? What is the genesis? Why was a particular decision made? I think all of this must be transparently disclosed so that the people and the public at large have a good sense of the context in which a decision was made, reasons, as well as somebody who's at the receiving end to also know, look, you fell foul of this. This is the protocol. You fell foul of this protocol. This is the prescribed punishment for that, and that punishment therefore follows. This is what due process would require.
All right, that's it. One other thing that actually you talked about degrees of stringency regarding content. You said that some stuff is manifestly unlawful, so it should be taken down within a certain set number of hours or a day. And in the article itself, you talk about Germany's law differentiates between content which is manifestly unlawful and it gives platforms 24 hours to take down stuff, and other less severe content which they have 7 days to take down. And this takes me back to the intermediary guidelines that the Ministry of Electronics and IT is actually trying to amend. And they don't actually have an approach that says, well, if this is severely offensive, then you have lesser time. And if this is not as severely offensive, you have more time. So what are some of the pros and cons of having such an approach as opposed to having, let's say, something like India is doing, where just there's no degrees of how unlawful a content can be, just it's unlawful, so you have to take it down?
I think the moment we look at what I call a new age economy, we must look at very nimble, agile regulatory framework and legal provisions so that it's a robust framework, but one which inspires confidence. The Prime Minister, when he made his grand announcement a few months back while announcing the package for the nation, focused on 4 L's, and one of them was law and the legal framework. So that's the kind of importance that legal frameworks are given. And therefore, the most important pro is that everything is prescribed and laid down like a menu card. You always know what is the items which are offered, and then you can make your choice for it. And that's the single most important pro, that every decision must be based on some normative parameters, or it must have a yardstick and founded on logic. So this is a very important pro. The con is that sometimes in the exigency of a situation or in an extreme situation, right, these things could act as a fetter because you require an immediate strike. So sometimes you need to do something if it's, let's say, related to the security of India, if it's pornographic, if it's to do with, issues which are sensitive, which requires an immediate redress, then sometimes, these things can come in the way, which is why you can always have an extraordinary provision which says that, okay, in such circumstances, exceptions which should be well defined, like security, the defense of India, you can immediately take an action. That would be justified and warranted in the circumstances. But in all other situations, as I said, you have a well laid down practice and procedure which is followed. There are well defined triggers so that decision making authorities and those who are subjected to those decisions clearly know that if you cross this line, this Lakshman Rekha, you will get a yellow card. If you cross this, you will get a red card. So this is what I believe a modern day robust regulatory regime must have. Complete clarity, complete certainty, complete predictability.
All right. I think you'll forget more about Section 69 more than I'll ever know. But you talk about the breakdown of due process in practice that's happened in Section 69A in the article. And you say that it needs urgent course correction, which I completely agree with. It's due process. I mean, if we don't have that, we have very little else to rely on. And this needs to be done in a balanced manner, right? But give me some sense of how this breakdown has happened. I mean, was due process a thing that was followed during the initial years of Section 69A, or and then brought down after, or what's the trend been like here? Has it always been shunned into a corner?
Let me first put it into two buckets. When a law is framed, it is not able to contemplate every situation. So you give what is called a general power. Then you have practice and usage, how things pan out over a period of time. And those then become good illustrations and examples of whether the power which has been given has been exercised validly, has it been done with some evolved procedure, or whether it's just happened by the way. And all good things start in a more collaborative and nuanced way, but sometimes they go unchecked because you take decisions, people don't necessarily challenge those decisions, those are accepted, then you convert that into the new norm, using today's word, like the new normal. So the way it evolves in practice or the ground reality could be very different from the way it was conceived. And this is what takes me to a word which I think is very characteristic of us, of our overarching system, which is the word discretion. Be it a policymaker, a regulator, or decision maker, everybody savors and enjoys this discretion. So you never have laws which, if I may use the word, completely do away with it, and sometimes for right reasons, because sometimes they have a legitimate aim or a specific purpose for which it is exercised. So framers of law and the Constitution had a lot of confidence in those who would man the institutions or the manner in which they would exercise the power. But because in India it's very subjective on the person and the people who man it, the trajectory could be very different. Let me give you a very good example of this. Let's take the office of the Chief Election Commissioner. Before Mr. Session became the Chief Election Commissioner, people would file electoral returns. There was no scrutiny. There was a cap on what you could spend on an election, but it would be exceeded, but nothing happened. So people took it as in their stride that there may be a regime, but nobody bothers, nobody enforces it. He came and he just cited the rule book and everybody fell in line. So it's the person who mans the institution, who sets the trend, who sends a signal. And that's a strength of our system. It's also a weakness of our system. And if you see in most of these cases, you have what I call initially gentle intervention, but then it becomes stronger and harsher. And sometimes I use the word regulators become persecutors or prosecutors, because once you've tasted power, there's no turning back. That is where course correction through judicial intervention, through change in law, through what I call much more forward-looking, far-sighted protocols and regulations. And if they can look at global best practices, you know what has worked well, and that's something which can be adopted, customized, and followed. So this is the trend and trajectory which I notice over a period of time, which I said is like a run rate thing. Starts off slowly, but once you escalate and you enjoy the taste of that power, then there's no looking back. So that's why sometimes it requires, as I said, some kind of effective oversight just to make sure there's no abuse or excess in the system. So we have what I call the regulatory adjudicatory system, which is a sort of system of checks and balances, that at one level a decision is made and then there's a higher forum which tests on the anvil of what we call adjudication under the rule of law, an independent and impartial mechanism of checking the correctness and the justness of a particular decision. So that's how you can balance these things if that process is very effective. I mean, just to digress for a second, you look at the press council that was made as an oversight body, but it's absolutely toothless. It can only censure, it can make a lot of noise, but that's about it all. So that hasn't really been effective over a period of time. So these are just examples of two institutions which I've given to buttress the point.
All right. One other thing that struck me while I was reading an article, generally I'm putting down notes while I'm reading, and you talk about how like blocking should be a measure of last resort. And like at the time when I was reading it, my initial thought was, well, if blocking websites is a measure of last resort, then what does that make internet shutdowns? Which brings me to my eventual point, which is that does the same due process that should be used to, let's say, enforce 69A, should that also be transmitted to, let's say, the power of internet shutdowns? I mean, are there caveats to that? What are your thoughts on this?
So first we have to see that, look, the internet has its own basic structure, right? that has to be kept core and intact. And we are looking at cultivating a good digital ecosystem, and we don't want roadblocks and hurdles. So this is where I bring in the whole constitutional principle of balancing. All these things require balancing. Shutdown is again a measure of extreme resort. Should we take recourse to it? What should be the circumstances if at all we do it? Should it be only extraordinary circumstances? And should it be very cautiously and sparingly used? So we don't want the 69A trajectory to apply itself to internet shutdowns, because then it will broadly follow in the same path. And that's what requires what I call forward-looking and far-sighted laws and regulatory measures which have a graded, proportionate and balanced perspective in view. That's the single most important thing that we should do. And again, like I said, there's so much of global benchmarking on this, best practices and trends. All of that must be factored in while we devise what I believe is the correct roadmap and protocol for internet governance. And when we look at, as you said, various forms of shutdown or lack of it for the internet.
All right. Final question, and then Prateek, if you have any, we'll ask them. But if you're led to have your way with Section 69A and how it's going to be imposed, what are the, in a hypothetical, what would be the first three things you do to change how this actual scenario is playing out?
Well, the first thing I would do is to open the Bible called the Constitution and think, what are the rights which have been guaranteed and what are the safeguards? I will then see the provision in the light of the Constitution and do a checklist. Yes, it is in line with the spirit of the Constitution as well, is the number one. Second, I will look at various examples over a period of time and sort of evaluate them to see, has it worked in the manner envisaged for the purpose envisaged, or have there been transgressions? And three, I will then suggest what should be the course correction or safeguards either within the framework of the law, or preferably what would be the modern legislation which would give power to deal with extraordinary situations with a heavy hand, but not make that the rule. It should always be the exception, and a system, as I said, an early warning system if something is going wrong, a graded response, a due process, prescribe that procedure so everything is transparently known upfront. Those are the three things that I would do.
All right, thank you, Prateek.
Yeah, so maybe just moving away from specifically 69A, right, and going to a more, let's say, more recent event. We covered the thing with the environmental advocacy group, but I also wanted to just for a second touch on the app bans that we've seen, right? 224 apps that have sort of been blocked, and under the reason of that they were prejudicial to the sovereignty and integrity of India, right? So, and I get the question that I sort of wanted to get at is, you made the important point, right? That there are going to be exceptional circumstances, and we need to define at least guiding principles to sort of define them, right? So I wanted to get your thoughts on, where you stand on, how do you see these sort of situations playing out in the future? And do you sort of foresee more of these sovereign restrictions per se on the internet? Just want to get your thoughts on that, because that's something that I think about a lot as well.
So I think, like you rightly mentioned, in a particular prevailing overall environment or atmosphere, certain decisions are made. So they have to be seen in that particular context. What's the backdrop? Because that's exactly how things happen. I mean, if we have, for example, we're all going through this COVID period. So whether it's policy making or court decisions, all of it factor in the phenomena called COVID. So sometimes you bend the law, sometimes you are able to provide effective relief, you take decisions on WhatsApp, unthinkable things happen. So paramount always is national interest and public interest. There's no doubt about it. If a situation warrants some kind of interference, absolutely necessary, justified, yes. But en masse decisions across the board, putting everything in one bucket or tarring everything with one brush, that I think is something which does not augur well. Because if you have a fast-growing digital economy, as India has, if you have a very well-settled set of constitutional principles and safeguards, then there's again, going back to my point, that rights and restrictions have to be balanced. And in a changing digital landscape and ecosystem, this really has to be in sync with our larger goal of becoming a digital economy as we are. So you have to look at what are the larger goals, national goals, whether decisions measure up to it, and not have knee-jerk reactions for a particular situation, because that never works. The ad hoc or steps never work in the long term. And you just go back to two defining moments. We had what I call the Enron moment for the power sector and the Vodafone tax case for India as a whole. They sent a very disturbing message. Thereafter, many steps were taken, actions were taken, measures, but that confidence level had gone down. So it's all about the measure of confidence that people have. And the measure of confidence comes when you have a defined landscape, a rule book, and everything is followed transparently based on that. So I think that's the way forward that I think this needs to be looked at. And again, as I said, the internet, the constitution had never thought of something called the internet, but they definitely thought of freedom of speech and expression and left that very broad. It's an expansive right. So perhaps it's time. We've had so many amendments to the constitution. We must really look at the internet, which is really the future, that it has its own basic features, and those basic features must be in line with the basic structure of the constitution, is as fundamental as that. So this is where I think some systemic changes are required to ensure that this thing is there for the longest of times. It's respected, it's treated well in terms of certain governance principles, and equally if there's any abuse or correction is required, the law provides for that trigger. It provides for a mechanism of dealing with and preventing the mischief that some of these things can be prone to from time to time. But one should see this through that lens, or see a few examples and then, look at the whole thing and, as I said, use one brush to sort of tar or mar the entire system.
Yeah, I think it's like that hard cases make bad law or something, right?
Yeah, absolutely right.
All right. This brings us to the end of our episode with Supreme Court advocate and also advisor of the Esya Centre, Gopal. Would you have any final comments?
Yes, my final comment is only this, that the internet is there to stay, and most importantly, what the message that India must send at this particular point in time as a fast-growing digital economy is that we have a rule of law and we have a set of procedures that we follow, and those are axiomatic and inviolable. I think that's a very strong message that we can send based on our experience and what we aspire to be in a changing digital landscape.
All right, brilliant. Prateek, do you have any final thoughts?
No, nothing from me.
Right, thank you so much for listening to All Things Policy. Gopal, thank you so much for your time. And thanks, Prateek. See you guys in the next one.
Thank you.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.
I hope you enjoyed that show. I'd like to thank our sponsors this week, Intel, for supporting us. Great week on the network. If you haven't been listening, why haven't you been listening? You should be listening. Rohan Joshi was on Uncle Please Sit, discussed the toxicity of the Indian pop culture. Really fun conversation to listen to. Rajiv Samant, the founder of Sula Wines, was on Cyrus Says. Again, I think that was a fun conversation. Also want to call out the season finale of Yuddha. Yuddha is our military history podcast. Definitely do check that out. It's a really great listen. And finally, I want to just remind you all that, it's a dark time, but if you need a smile, go check out the Smile India podcast by Shifa Mehta. It's in both English and Hindi, and I think that you will really enjoy the kinds of things that she's talking about there. And with that, I hope to see you again next week.
Are you constantly seeking happiness? Wondering how to make the most of every day? How not to let your inhibitions stop you from achieving your goals? It's now time to get your A game on. It's time to unlock your true potential. Tune in to the Empowering series with me, Zarina Poonawalla, to feel empowered in all genres of life. From behavioral skills to management skills, from health to relationships, from mental well-being to emotional well-being, and of course your finances. I've got you covered. With these tips and tricks from me, Zarina, and true life stories from my amazing guests, you're bound to bring your purest to the table. Tune in to the Empowering series with Zarina Poonawalla every Thursday on the IVM Podcast app, website, or wherever you listen to podcasts.